This is continuing coverage. The Black Swan murder trial of Ashley Benefield from the Hidden Killers podcast and True Crime Today. Now back to the courtroom.
In evidence, it may be in the file somewhere. Is it attached to something so I can find it?
I can give you a copy.
Any objection to me receiving a copy? I assume it's filed somewhere, but I don't know where.
Judge, may I make a statement briefly? In my past experience, when my CV is presented to the judge, oftentimes I'm shown a copy to verify that that's the complete version.
Sure, you want to see it?
Yes.
Absolutely. I'll say, Mr. Taylor, there's markings on it. In the back. Is it in the court file?
I don't know if it's attached to the deposition. Let me take a look.
So here it is.
No. I'm informed we don't believe it's in the court file.
All right. And so, sir, this appears correct?
Yes, it does. Thank you for letting me look at it.
State, the copy that I've been given looks like there's highlighting where someone was making notes to highlight certain things to talk about. There's a couple of pages where there's some red in markings where something has been circled or underlined. Any objection to me taking this and reviewing it?
The defense's burden. My only concern about your asking questions is that they have arrested their witness, and I understand what Your Honor, I have a guess as to what your questions will likely be, but that is my only concern. I don't know what objection that would be, but
I mean, don't forget there's also the general improper. So you object away.
Yeah,
you know me, I don't mind.
Yes, sir. Yes, sir.
All right, and then you had gone through a list of 13 things that you had reviewed.
Yes, sir.
And I was writing them down as we went, and I'm taking notes. I only got 12.
Okay, so do you want me to briefly?
I don't want the narrative portion.
No,
I just want you to tell me.
Or you tell me. Okay, I'll tell you.
No, it's got to be the other one. You have to say to me.
I'll give you the first 3 or 4 words of each. Number 1, deposition of Doug. Number 2, letter to pasture. Number 3.
A little slower.
Okay, sorry. Number 3, DV injunction from South Carolina. Number 4, 9/18/17 letter from Ashley. Number 5, deposition of neighbor. Number 6, text of Doug admitting. 7, text from ex-wife. 8, the DV injunction. That's Manatee County. Number 9 was Dr. Russell. 10 was the telephone calls between Doug and Ashley. Number 11 was the WhatsApp phone messages between Ashley and Doug. Number 12 was the Roeder testimony. And number 13 was the text kick dog through cat between Ashley and Doug.
Can I just ask to verify, you said phone calls between Ashley and Doug? What did you say?
Yes, from 8/16/2019, I have a transcript of phone calls between.
You have a transcript of phone calls?
I believe so.
All right, that's all the questions I had, surprisingly. State, do you have any questions based on my questions? No. Mr. Taylor, do you have any questions based on my questions?
No, Your Honor.
All right, and is he free to head on back to Gainesville?
Yes, sir.
Okay.
Am I released from my subpoena?
No, this is just a proffer.
Okay.
We're doing a Daubert hearing, so I imagine Mr. Taylor still has you under subpoena.
We have high hopes you will be returning early next week.
Okay.
So stay in touch.
Okay.
Right.
And so I'm still under my subpoena.
Yes, sir.
Thank you. I do appreciate your attention.
Absolutely. Have a great weekend. Don't forget you've also got your wheel over here. Or was that yours?
That's theirs.
Okay.
I've got my own. Thank you. Thank you.
Sir. Safe travels back home.
Yes, appreciate it.
Well, we're looking you go right at the perfect time, aren't we?
Yeah.
Might want to stop and have dinner.
Or pack up my hotel room and put my blue jeans back on, right?
Yes, sir.
Thank you.
All right, the witness has left the courtroom. Did you have any other witnesses' testimony or evidence you wanted to put on for the Daubert hearing?
No, sir.
State, did you have any evidence, testimony you wanted to put on? All right, I'm ready for argument.
So 702 of the Florida Evidence Code, Your Honor, incorporates the new Daubert standard, as the court knows, provides if scientific, technical, or other specialized knowledge will assist the trier of fact in understanding the evidence or in determining a fact and issue. A witness qualified as an expert by knowledge, skill, experience, training, or education may testify about it in the form of an opinion or otherwise if, and the court knows the three requirements. Sufficient if the testimony is based upon sufficient facts or data, testimony is a product of reliable principles and methods, and 3, the witness has applied the principles and methods reliably under the facts of the case. The state's theory of prosecution, although it was changed this afternoon from the release of the Broder report to the injunction that was set for the 30th, has as its predicate the specific behavior of Ashley Benefield in the week leading up to and included in those text messages, as was the video at the restaurant, as well as the state's focus on how Ashley Benefield behaved in the presence of Douglas Benefield, but behaved differently when she was by herself, and how she led Douglas Benefield to believe that she wanted to reconcile, but in private, she clearly disclosed that she did not want to do that and wanted the relationship over. And finally, the instances where Ashley Benefield, as a result of the parental time sharing, accompanied her daughter, Emerson, and went with Doug, that Stephanie Murphy testified to. They were the picture of tranquility, that Ashley was very pleasant, happy to be in Douglas's presence. So what we know and what the record reflects based upon Mr. Ferris's testimony and the Duluth Power Wheel and its model for the evaluation of domestic abuse is that this is a classic sign of an abused woman who is in compliance, who indulges in, as Dr. Broder used the term, appeasement. Go along, get along. It keeps the beast at bay. And now that element having been injected by the state in their case in chief, we, on behalf of Ms. Benefield, are prepared to meet with expert testimony explaining to the trier of fact, jury in this case, exactly why the state's evidence of Ms. Benefield's compliance can be dismissed, can be explained, because this is the MO of abused women, women suffering from domestic violence, especially when a child is involved. So, here's what, as the court knows, the Oquendo decision said, and it's the second DCA decision, referring to battered woman syndrome. Again, the notice we filed was notice of battered woman syndrome, but I footnoted it because two elements are not present. Those two elements are that Ms. Benefield had left the home and that she had not been physically battered by Mr. Benefield until the day of the homicide. But as the court heard from Mr. Ferris, it's inconsequential. It is the same syndrome. It is the same abuse. It carries over, and it explains under Duluth Power and Control Wheel why Ms. Benefield would engage in those kind of text messages 1 week before the shooting, why she would appear happy at the restaurant, why she would accompany her child at parental time sharing with Doug, why she would try...
Please not get behind me. I'm sorry, but...
Why she would try to get along, go along.
but I don't want you behind me.
So here's what the Oquendo court said. Well, actually, before we go there, we should go first to the Supreme Court case of Kathleen Wyan versus the state of Florida. This is the case I cited to the court earlier in a memoranda, 732 Southern 2nd, 1044. It was an appeal from the 2nd DCA.
Oquendo.
Yes.
Yeah.
No, this is Wyan. Kathleen Wyan, the Supreme Court of Florida. I'll get to Oquendo next. And the Wyan decision, Your Honor, was March of 1999. The Supreme Court rejected the 2nd DCA's position in the Wyan case and instead embraced another circuit's decision, and it turned on the following question: whether or not there should be a duty to retreat as it applies to a spouse in the marital home. The Second Circuit had insisted on giving the instruction in a homicide case. The Supreme said, hey, look, we've learned quite a lot about domestic violence, and we're uncomfortable having a duty to retreat imposed upon a wife because of domestic violence. And it would render the wife's ability to defend herself in the face of battering and domestic violence ineffective. So we're going to reject that. We're going to retreat from our earlier decision that held there was a duty to retreat. And this is what they said about why. It starts on page 1052. And the topic is Section B, Implications for Victims of Domestic Violence. And they talk about how much of the public policy in this state has changed based upon increased knowledge about the plight of domestic violence victims. It is now widely recognized that domestic violence attacks are often repeated over time, and escape from the home is rarely possible without the threat of great personal violence or death. During repeated instances of past abuse, she has retreated only to be caught, dragged back inside, severely beaten again. If she managed to escape, other hurdles confront her.
While you're taking a breath, how is Wyan to help me decide the Daubert question?
The issue is whether or not he has the credentials. I think we're past that. Unless I'm missing it, I think he's eminently qualified. I think the testimony is such that he's identified the syndrome of domestic violence, and he's explained that it is identical to battered spouse, the only difference being that the wife is not in the house and she has not sustained physical beatings. So this case in Wyan goes on for several pages talking about how domestic violence, the evolution of public policy, and the recognition of the plight of victims of domestic violence needs to be addressed and should be addressed by virtue of expert testimony. When you take that into account and you recognize what the Supreme Court is acknowledging, Judge White, about the timeliness of domestic violence, which is the overarching umbrella, battered spouse and those two components coming underneath it, you then go to Oquendo. And in Oquendo, they serve it up perfectly. Under Florida law, battered woman syndrome is not a legal defense, but rather is used to explain the woman's experiences and state of mind in the jury. In the context of self-defense, it is used to show that because of the prior conduct of the batterer, the woman reasonably believed that taking the batterer's life was a real necessity. And then they distinguish post-traumatic stress disorder. And they hold, as such, unlike PTSD, it is possible for battered spouse syndrome to be relevant in a way that is consistent with the objective, reasonable person standard for the justification of self-defense. So we know in a homicide case, based on the law and the jury instructions, Ms. Benefield is entitled to introduce specific instances of conduct of Douglas Benefield that are consistent with violence. We have endeavored to do just that throughout this trial thus far, with considerable resistance, but I think we finally started making some progress once the court felt the predicate had been laid. We cannot, this jury must understand, and both the case law that I cited to Your Honor clearly says that it is a proper subject for expert testimony, domestic violence. These jurors must understand why a woman would do what the state has alleged she did, and as a result, they should find her guilty. That is to say, getting along with Douglas Benefield and the text messages that they put into evidence. So, given the credentials that he's established, given its reliability, given the tests that it's been vindicated with and that DCF employs, the Duluth Power Control Wheel throughout the state of Florida, given the fact that this is a domestic violence matter involving self-defense with specific instances of domestic violence, how can I successfully defend if I cannot explain to the jurors the essence of the state's case as to why Miss Benefield is a malingerer in effect? That is to say, if she acted happy 1 week before the shooting, if she went ahead and got in a car with Doug when they were exchanging temporary time sharing, if she acts happy at the restaurant, then she obviously wasn't scared of Doug. And that's the whole issue. That's exactly what was at play on September 27, 2020, and why Miss Benefield's perception of Douglas Benefield was so fraught with fear. Otherwise, I'm left with a case that there is, in fact, a substantial explanation to explain that conduct that the jury doesn't understand, as indicated by the case law in the Florida Supreme Court, and will have no idea why Ms. Benefield would have acted that way. And it's an element that the state introduced. We are trying to meet it. That's our position.
All right, thank you. State?
Judge, I'm going to try to bring it back to Daubert, but I do want to address Kendo because it frames my arguments. Sorry. Under the Okendo case, or Oquendo, however you say it, the court carves out, as we've discussed at length, and I know Your Honor knows, carves out an exception for battered spouse syndrome, where it's talking about that it's an objective standard. Self-defense is an objective standard, not a subjective standard, and that the one exception for that, and under Okendo thus far, is battered spouse syndrome. They discuss the definition of battered spouse syndrome. And part of it says, the main part, mental state so that she could not be responsible for her actions. Rather, the testimony would be offered to show that because because she suffered from the syndrome, battered spouse syndrome, it was reasonable for her to have remained in the home and at the pertinent time to have believed that her life and the lives of her children were in imminent danger. The Whelan case also defines battered spouse syndrome. It says,
You want to spell it?
sorry, it's the case Mr.
Wyand?
I'm sorry, Wyand.
Whatever, however you want to say it. I just need to know which one.
Weiand, 732 Southern 2nd, 1044. It says, I was looking for the page, Your Honor, I'm sorry. I think it's on 1054. It says, as the expert evidence demonstrates, there are many reasons battered women do not feel free to leave the battering relationship. This woman might have been isolated from her family by the abuser. She may not be able to afford to go, and she may realize that leaving is more dangerous than staying. And the reason I cite that is because the state's argument is that despite Mr. Taylor's efforts to make this about battered spouse syndrome, despite his footnote, that is not what this is about. This is them trying to get an expert on domestic violence. This expert, Mr. Ferris, while very educated in domestic violence, is not a battered spouse syndrome expert. He does not say that this defendant, although I find it incredulous that he spent 15 to 20 hours with her and reviewed things that the state doesn't even know what they are, that he only based his opinions on those documents not meeting with her. But nonetheless, if he were evaluating, the reason that's important and the state asked it is because if he's evaluating her for battered spouse spouse syndrome, which he clearly wasn't, because he admits he does, that's not what he was doing. There's only two options for that, and your Honor's aware of that. That one, if she's evaluated, then they have to file notice and we are allowed to evaluate her. That's not what we're operating under here. So the other one is that their expert must not have evaluated her. And the state would argue that no matter what Mr. Ferris claims, that's an evaluation. The things he did were an evaluation. I believe the case actually, I think it's Hickson, but I could be misspeaking, even says that they're not supposed to be familiar with the facts of the case. He's clearly familiar and has formed opinions, personal opinions and professional apparently, about the facts of this case. And the reason that's important is because the state would argue that this defendant has failed to meet her burden under Daubert, that this expert is an expert in battered spouse syndrome, that the testimony is based on sufficient facts or data, and that it's a product. I don't think he met any of the prongs as to battered spouse. As to domestic violence, I would admit he certainly has the skill and knowledge. But even then, I don't think that the methods were reliably, it says the witness has applied the principles and methods reliably to the facts of this case. The facts he got were incomplete and evidently biased, because some of them include items that were never provided to the state, including transcripts of phone calls that the defense felt were appropriate. So the state's argument is that, one, the only option for them is battered spouse syndrome. They have certainly not met the burden for that. Under Okendo, the domestic violence should not be admitted. And two, that they did not meet their burden under Daubert because they did not satisfy the prongs of Daubert for domestic violence if it were admissible. And I don't know what they expect Mr. Ferris to actually testify to. I think 75 to 90% of what he said today is inadmissible. Stories about other people, those kind of things. The state is of the opinion that his opinions that this defendant is a victim of domestic violence are inadmissible. That's an inappropriate opinion for him to be making. And finally, the main prong that they have not met, in the state's opinion, is that it says if the scientific, and I'm citing Booker, but it's from Daubert, the scientific, technical, or other specialized knowledge will assist the trier of fact in understanding the evidence or determining a fact at issue. The state has put forth motive evidence and evidence of how she was acting in the weeks before this murder, and it certainly goes to her depraved mind. But the concept of domestic violence and even the concept of the Duluth power and control wheel are not foreign to the average citizen. That an average juror, and this expert's scientific, technical, or other specialized knowledge would not be necessary to assist the trier of fact in understanding the evidence. The evidence is clear, and the jurors are people who are of normal knowledge, and it's a common domestic violence situations, and the idea of power and control, honeymoon phases, those kind of things are common knowledge. So I know I said a lot of ways in which we object, but I don't think they met their burden under Daubert for battered spouse syndrome, certainly. I don't think they've met it for domestic. But even if Your Honor finds that they have, the state would argue that Okendo would keep that testimony out of this trial, as it's an objective standard, not a subjective standard. Thank you.
Rebuttal?
Yeah. Mr. Ferris was asked directly if he evaluated Ashley Benefield, and his testimony, which is the only testimony that's been brought forth in this hearing, was that in no time did he conduct an evaluation. He was not hired to do an evaluation. With respect to the state's statement about motive evidence, motive is not an element of the offense. However, self-defense is certainly a material element to be considered, and there is, according to the information that is discussed in the Supreme Court opinion, Your Honor, it is not, and decidedly not, a subject for lay testimony. They could not make it more clear that there are many aspects about domestic violence. In fact, the words that they use in the Supreme Court opinion is that judges and juries do not understand and would benefit from expert testimony. I would suggest to the court drawing a distinction between Daubert and the case law on battered spouse syndrome. I would suggest that, given the facts of this case, an expert such as Bruce Ferris, who could educate the jurors on the impact of an abused relationship, domestic violence, in and of itself would be enough to provide expert testimony to counter the state's position and the issue that they raise about go along, get along. I think it's clearly beyond the scope of lay people to understand that. And I think that expert testimony would help explain it. So Daubert, of course, doesn't apply any less under those circumstances. However, it would not be restricted to the extent the court wanted to draw such a narrow line and say, for example, okay, well, this is not battered spouse syndrome because for it to be battered spouse, you absolutely must have the abused party living with the abuser, having had physical beatings. If the court wanted to draw a line that narrow, rather than include it under the umbrella of domestic violence, I would still submit to Your Honor that the testimony from Bruce Ferris clearly met the Daubert standard for admissibility, and I would call him as an expert witness on domestic violence. And if the court really wanted to narrow it even further as it relates to a woman who would choose appeasement and go along, get along, coincidentally, like I think we had 4 psychologists testify in this case so far, and every one of them have used the same terms to describe this phenomenon. I think I need and I should be entitled to be able to explain that to the jurors, and I'm not going to be able to do that without expert testimony. So I think the state combines Daubert with case law, and Daubert is the procedural vehicle for allowing expert testimony.
All right, I do have some questions.
Yes.
I end the week, kind of as I mentioned at the hearing we had regarding Mr. Ferris before the trial started, whether it was last week or the week before. On July 11th, at a hearing, you said this was not a battered spouse case. On July 12th, filed the notice of intent to rely on battered spouse syndrome. What is this? Are you arguing battered spouse syndrome or not?
Okay, Judge, once again, I filed that notice with a footnote in the title, Notice of Intent to Rely Upon Battered Spouse Syndrome, footnote. The reason why I told the court this is not a battered spouse case is because technically, Your Honor, battered spouse requires those 2 elements. I shouldn't even say it requires those 2 elements. Those 2 elements are generally present in the battered spouse cases that we've seen. So in my footnote, I said as it relates to domestic violence. So I wanted to cover both scenarios. I wanted to cover expert testimony to explain this phenomena under battered spouse as it relates to domestic violence because it's the same syndrome as you've heard. It's the same mentality. Everything about it's identical. But I also felt at the same time entitled, upon meeting the Daubert standard, to just call an expert on that particular issue. And this expert's eminently qualified to explain that kind of behavior. So Daubert is, again, the procedural vehicle that qualifies whether or not the expert is capable of meeting the standard. And that would apply whether it was to battered spouse or just as domestic violence.
All right, so we've got the case law that we've all been discussing for the last couple of weeks regarding battered spouse syndrome, the notice that's required, why it's a carve-out, why it's allowed when Okendo doesn't allow PTSD, other cases don't allow significantly impaired intelligence, mental health issues. When I say mental health issues, I'm not talking insanity and so forth. I'm talking about, diminished capacity, right? Essentially diminished capacity because we're looking at a reasonable person. Do you have cases that do not use the word battered spouse syndrome? They use domestic violence victim of domestic violence, and that is allowed in self-defense cases.
Would it be any different, Your Honor, than a criminal case of culpable negligent homicide, the issue being the trigger pull and the weight that in order for the weapon to fire? And you're an expert to testify that the trigger in that particular gun was set to a particular level to try to explain to the jurors why that gun might discharge, and you're not necessarily negligent because of the discharge. Other weapons, if you banged against the wall, might not discharge. This one has a hair trigger. The defendant turned, hit the banister, the weapon discharged, shot and killed somebody else. If that expert met the Daubert standard, why wouldn't that expert's testimony be admissible to explain that? To try and explain to the fact finder who would not have that knowledge that indeed this could be nothing more than an accident that does not rise to culpable negligence, and therefore the charged individual is not guilty. And what I'm saying to the court is that evidence of domestic violence, if it meets the Daubert level, I should be entitled to defend and explain to them why she would engage in this type of go along, get along.
So the answer is no, you don't have a case.
I do not have a specific case on that point, no. And so the court knows I instructed Mr. Ferris not to evaluate Ashley Benefield. I had planned, if it came in under battered spouse, to follow the Heenan option, whereby he would be given a series of hypotheticals based upon facts and evidence.
Excellent segue. That was my next question. I didn't keep track on the clock how long Mr. Ferris testified about the general properties of domestic violence, the Duluth wheel, the cycle of violence, his numerous anecdotes, personal anecdotes, and relatable anecdotes. But if I'm understanding correctly, you are going to seek for him to offer an opinion that Ashley Benefield was an abused person and Doug Benefield was an abuser. Is that correct?
No, not necessarily. That was for purposes of the hearing that we had. It would be my plan, if he comes in under the Heenan approach to battered spouse, Your Honor, to just have him educate the jurors about domestic violence and specifically ask him about the compliance aspect that would allow a woman to engage in the type of behaviors that the state has raised the issue about and injected the evidence that they have. I could then give him hypotheticals based on facts that were in evidence under the battered spouse syndrome exception, or alternatively, were he to come in just as an expert on domestic violence, I had him review the discovery materials. As the court knows, he submitted to a deposition by the state under the Heenan approach or under just domestic violence expert, as it says in the case law, would have had the option to get their own domestic violence expert. They haven't done that.
My ultimate question was, at one point you asked, can you relate these concepts to a domestic violence situation? Yes. He can study facts and documents. Can you relate these concepts to a situation where you study the facts and documents of a particular case? Yes. But you're saying you're not doing that. You're doing hypothetical. He's not going to render any opinions in this case.
Correct.
Specific to this case.
If it comes in, under battered spouse syndrome. That's correct, Judge. I would follow the Heenan approach.
I think it's Hickson. Are we talking about Hickson?
No, I don't think it's Hickson. I'll get it to you.
Judge, I know it's not.
It's
I would
this.
like to hear us that when if they'll allow it once we're done.
It's in Hickson, but the case is Heenan.
My question is this. He spent so much time on these Hornbook issues, and the question was asked, can you apply these principles to hypotheticals? But I didn't hear a single hypothetical that's going to be presented, so I could even hear him and consider him and listen and see if he applied the principles reliably to the scenario. So I have no idea, how am I going to make a ruling when I didn't even hear the hypothetical?
Well, the hypotheticals would be based on evidence in the record.
I understand.
I took him up to that threshold, and I asked him, could you reliably apply these principles to a series of hypothetical questions if asked? He said yes.
So why didn't you ask the hypotheticals so I could hear them and make a ruling?
Well, I would ask the hypotheticals, Your Honor, based on what we know is record evidence for
Exactly. What's in the record, what's been admitted.
correct, but
Is it your position that all 13 of those items have been admitted into evidence?
no.
So I would need to hear the hypotheticals to know what you're going to ask about.
Okay, so I would ask the hypotheticals, Your Honor, based upon shooting the gun in the ceiling. Actually, I would ask the hypotheticals based upon the evidence that the state has presented to create the issue. For example, I would ask, in a week's worth of text messages were to be exchanged leading up to a shooting, that emojis and friendly banter back and forth, would that be inconsistent with battered spouse syndrome? I would then ask, would a woman who shares a child and the husband has a right to joint custody, and the woman agrees to go along with the husband when he is with the child, would that be inconsistent with battered spouse syndrome? And he would explain in response to those types of hypotheticals why it wouldn't be, why this issue of compliance exists and is so prominent in domestic violence cases or in battered spouse syndrome cases. I mean, the hypotheticals, I think, are readily available based on what we have, record evidence. Now, I might also add, Judge, we've only called, I think, 2 witnesses, so there may be more that's in the record. But to the extent that I'm interested in it, it will relate to this issue that the state is teed up about acting friendly and not being fearful being in the company of the individual. It doesn't mean that they're not fearful.
Hold on.
Once again, Your Honor, I had him review the discovery documents in the event he came in as an expert on domestic violence and was going to speak to that issue.
Thank you, sir. All right, State.
Judge, I guess based on that line of questioning, I'm still not sure what the answer is to your first question, which is this a battered spouse syndrome case or not? I would argue that it is not, that there's been no showing that battered spouse syndrome applies in this case. And I think that's my first argument. As to the hypotheticals that we did not hear today, the state objects to the hypotheticals being offered to this doctor, because under Hickson, if this were battered spouse syndrome, which is really all we have for guidance, it would have hypotheticals are available to someone who has not evaluated her. And I think because I know he said he has not evaluated her, but the fact that he read 13 items in this case, he's wholeheartedly familiar with what the defense believes the facts are in this case. And I think it would then be inappropriate for him to be asked hypotheticals based on what is in the record. Because clearly he got a lot of things that are not in the record. That's it, Your Honor. Thank you for letting me be heard.
Okay, anything else we need to take care of before I let you go?
Nope.
When do you plan on calling Mr. Ferris?
Like to call him first out Monday morning, Your Honor.
Okay.
Do you think we'll be rolling on the weekend or Monday? Is there anything, I did have one question. Is there anything in here on Monday morning before us, or can we leave some of the things we've been leaving?
I'm not aware of any hearings Monday morning.
Thank you.
Sure that one's turned off.
Thank you for having the hearing. It's been a long day, but I think it was good for us.
Yes.
More continuing coverage is on the way. The Black Swan murder trial of Ashley Benefield from the Hidden Killers podcast and True Crime Today. Press subscribe now.